Hi, I'm Steve Haynes, CEO of Data Center Trade Association, and welcome to what is the last in a series of 3 sessions we have with Conexus Law relating to legal issues arising from COVID-19. So I am delighted to welcome Marilyn Heyward-Mills from Conexus Law here today to help us field some of those questions. Marilyn, welcome. I'd first like to address maybe the economic impact of COVID-19 and ask you what employers can be doing, I suppose, to ensure that they stay on the right side of the law, especially as the workforce is shifting and moving, and employers are having to ask their workforce to work from home and potentially, sadly, even potentially losing their jobs or being made redundant or to furlough. So perhaps you could provide some advice and guidance around how employers can make sure that, as I say, they stay on the right side of the law.
I mean, this is unfortunately an issue that more employers are having to think about and grapple with, and it's all still unfolding, isn't it? The sort of impact of this pandemic. I think that before you come to actually dismissing employees, one of the things that employers should think about are some of the alternatives. So, you know, very simple things that people forget often. If you've got offers out there, you can just rescind them if they haven't been accepted. If you've got offers that have been accepted but people haven't started, again, you can probably dismiss or end those contracts quite cheaply. So those are things to think about. And then if you've got clauses in your contract that allow for short-term working or layoffs, that you think about implementing those and reducing work hours, because there is a general obligation to think about alternatives to just straightforward dismissals and redundancies. If you've gone through that whole process and there really isn't any other option but to cut jobs, then really you come into the world of the unfair dismissal. You know, employees who've been employed for 2 years have protection. Some employees have protection irrespective of the length of service, like, you know, pregnant employees, and there are other various statutory protections. But if you are thinking that you have to make redundancy, I mean, the thing to bear in mind is that the sooner that you can inform your workforce, the more open you can be with them, the more you can communicate really the options that you see and get them involved, the better all round. When it comes to making redundancies, there's obviously a whole raft of you know, regulations, requirements that an employer has to comply with. So really the first thing is to look at how many people that you think you have to get rid of through that process. And if it's 20 or more within a particular time frame, 90 days, you've got to consult collectively with them, which involves consulting with the actual individuals or with representatives or elected representatives or trade unions, whatever, depending on your workforce and depending on if it's unionized or not. And then you've just got to make sure that, you know, at that point, really, the ideal is to have either somebody in the HR who knows what they're doing or get your lawyers involved, because you've got to make sure that you are, you know, you're doing it correctly. You've got pools, you've got criteria that you're working with, that you're selecting fairly, and that the process is a fair one. So again, it's step-by-step consulting with employees, step-by-step informing them, making open decisions that you can justify, keeping a paper trail before you ultimately select individuals to make redundant. So really, it's irrespective of the pandemic, we're back in that realm of just ensuring that we're complying with the unfair dismissal and the statutory employment protections that we have in this country.
Thank you, Marilyn. Hopefully that'll be helpful to many businesses and employers alike. So I have a question for you which came in. Let me just make sure I've got this right. So we've got an employer who's furloughed its staff. Those employees have come back after 4 months. The employer has told the employees that he can't afford to pay them for unused leave, and equally he can't afford for them to take that leave either because he needs them to work. So his solution is to do neither. So clearly there may be some employment issue, contractual issues there arising. I'm wondering what advice you can give both to the employee and the employer.
Yeah, I mean, this is a great question. And it is a complex one. And I can see the attraction to just deciding that this is going to work to just cut holiday costs. But it's certainly not a legally sound approach. It's a complex one because I think there are a couple of things that we could tease out. So, you know, first of all, how much leave has the employee got left? Because under the working time regulations, what is really protected are the first 20 days, right? So if the employee has taken less than 20 days, then you're looking at leave that the working time regulations say have to be taken or can be taken in that year under normal circumstances. And then if it's beyond the 20 days, that's leave that can be transferred into the next year. But earlier this year, amongst the raft of amendments made to our regulations and legislation because of COVID, there was an amendment made to the regulations that allow leave to be carried over to the next year. So first of all, that the leave can be carried over now, right? So that's the first thing. And then the other thing to bear in mind is can the leave then be paid or not paid? So the regulations provide for two separate rights: the right for the leave, the right to have the leave, and the right to be paid for the leave. And interestingly, if the employer decides, as it seems that they're saying in this situation, that you can take leave if you want, i.e. we're not necessarily going to postpone it to next year, but we're not going to pay you. There was a case a couple of years ago that went all the way to the ECJ on this point. And the ECJ determined that you can't separate these rights because if the employee thinks that their leave will not be paid, they won't take the leave, and that defeats the purpose of the regulations. And this case was due to come back to the Court of Appeal to have a look at whether our regulations needed to be changed, but it got settled. So it hasn't come back in that way. It's unlikely, though, however, that a tribunal would determine that that doesn't apply and that the leave needs to be paid. So in this situation, what the employee's rights would be to have, to be able to take leave if it's not, if they can't agree between them that it should be postponed to next year, and for the leave to be paid. And that's really the remedy, is to go to tribunal, to have a declaration made and have the payment made. The issue that a lot of people are facing is you can have those rights, you can go to the tribunal, you can get a decision, and if the company doesn't have the money to pay you, that becomes the issue, right? So from the perspective of the employee, yes, you can pursue the claim. From the perspective of an employer, the things that I would really recommend would be, again, going back to the employees. If you need to have holiday postponed because you need people, on the job, have either look at your contract and see what that says, whether that permits you to do that, or have conversations with your employees about that and how you're going to manage the postponing of leave to the next year and guaranteeing that you will pay it, right? You need to also be aware of the well-being of your staff. People need breaks. So employers have a duty to look after the health and safety of the employees. So you need to also be aware of the fact that just because you don't want people to go on holiday or it doesn't suit, that's enough if they agree. You need to be aware of the fact that people need breaks, particularly in this environment. As far as paying, again, the employers can figure out ways to negotiate with the employees about either maybe reducing their work hours so that they have reduced holiday, and or agreeing that they'll postpone the payment of the holiday till next year when things pick up. But again, I would recommend that, given the climate, people do try to be open, try to negotiate, try to draft new agreements. Otherwise, you are falling foul of the law and opening yourself up to needless claims.
Thank you, Marilyn. I have one final question for you. It's actually two questions in one. With so many members of staff working from home and working remotely, I'm having to maybe take up the slack of fellow employees or colleagues who are no longer with them and have been made redundant. I was wondering what responsibility the employer has to making sure that the workloads are evenly spread between employers who are working remotely, and also whether they have a responsibility to the welfare of those staff as well, working from home as well.
Great question, Steve. And yes, so there is an obligation, there's a health and safety duty, there's a duty of care to employees that employers have in this country. And that duty covers employees that are working remotely. So it's not just a duty to provide particular policies or whatever within the office environment or the data center. So you have a duty, so that the health and safety policy, I would say that's the very first place. How you have a health and safety policy, and you need to be sure that it has been appropriately tailored for remote working, and that you include in there various things that will enable your staff working from home to work in accordance with that policy. So you want to be sure that they have the right equipment, you want to be sure that they are taking appropriate breaks, you want to be sure that just because they're at home, and therefore it might appear that they have some flexibility about how and when they do their work, potentially, that communication is kept open and clear, that they are required to take breaks, that they should stop at reasonable time, and that they manage that process, and that is part of the responsibility in terms of health and safety. What you don't want is, for example, an individual at home and having multiple managers, none of whom are communicating with each other, overloading one individual who at home then thinks they need to work all night to get this done because nobody can visibly see what's happening. So that, the duty to ensure that your workforce are coping well, that is possibly slightly heightened in this environment, I would say, because again, you've got people at home that are doing multiple things. Although kids are back at school, there's a lot of them being sent home periodically for because somebody in their class or in their school has tested. So the people are dealing with a lot of various demands now that are quite overwhelming at times, and I think employers should be mindful of that in the way that they deal with their employees. So yes, those duties. So you want to be performing all those routine checks, you want to be communicating regularly, you want to be having open forums where people can raise concerns, you make sure that line management has a clear access to individuals, that the communication is kept going. Those are things employers can do. And then in relation to where the workload has increased, it's really the same thing. You have a duty to your employees to ensure that they're able to, there's also duty to not let them be working excess hours, hence the working time regulation. So be mindful of the number of hours that they're doing and the increased stress on people for having to take on other workload. So yes, it's all lumped into the same thing.
I think one thing that's been really interesting over this whole pandemic and lockdown period is the social experiment, I guess, for want of a better word, of remote working. For years, staff have been required to go to offices because their bosses would prefer to see them at their desks, maybe not trusting that they'd actually be productive at home. And I think that's been proved unfounded over the last 8 months. So that's definitely one positive thing that's come out of the pandemic as a social experiment, for want of a better word. It's I think it's going to have some impacts that need to be addressed. Marilyn's addressed some of those in respect to well-being and the support that businesses need to provide their employees when they are remotely working. There's obviously some issues around the impact it's going to have if it affects the commercial market in respect to office space between landlords and tenants, and there may well need to be some more flexibility there as well. So interesting days that lie ahead. But as this session draws to a close, I'd maybe just like to ask Marilyn for her final thoughts to close the session off. I
mean, I think, it feels as though there's been a lot of talk over the last few years about mental health, and about employee well-being, and about stress in the workplace. That has all become really relevant for all of us. So individuals' responsibility for their own well-being, employers being more aware of that. And I think, in a sense, that's one of the things, that is, I think one of the key things that employers really should be and are embracing, I think, a lot of the time in terms of how they relate to their staff as human beings in a way, rather than statistics. You know, as human beings dealing with all the stress of the pandemic, the stress of the sort of the uncertainty, and the stress of working from home. And I think open communication, keeping the dialogue, going, keeping some online communication with staff, and some sense of connection despite the disbursement. And really, I would say the key word for all of us and for employers particularly is flexibility and just remaining open to new ways of doing things and reacting to new legislation that has been thrown at us. That would be my final thought.
Thank you, Marilyn. This concludes this session. However, what I'd like to do is just ask Ed Cook to provide his final thoughts to conclude this briefing. So over to you, Ed.
Thanks, Steve. Well, thank you, and thanks to Ian and Marilyn as well for their input into this webinar today. I think what I take away is actually that what we have talked about in this webinar is all about communication. So whether that be, as Marilyn's talking about, communication with employees, or Ian's talking about communication with somebody who you may be in a dispute with, and how you can use kind of mediation communication as a tool to kind of be more creative about how you resolve that dispute, and me talking about communication and relationships with suppliers and with people who you work with. So I think that's part of that's the kind of theme for me of this whole webinar. Really has been about maintaining communication throughout this period of difficulty. And I guess with that in mind, I'd just like to say that I hope this webinar isn't the end of the conversation with your members, Steve, because we really are keen to hear about what issues your members are facing, and really try to, we're always happy to kind of come on here and do a webinar addressing a particular point. If it's of general use to people, people will find a bunch of information on our new website at conexuslaw.com. So please just reach out to us, ask us questions. We're really keen to understand what issues you're facing and try and help you resolve them.
That's the end of our briefing session. I would like to thank Conexus Law and to Ed, Ian and Marilyn for their support, advice and guidance. These sessions are recorded for you to be able to review at a later date. If you have any further questions which are of a legal nature, then you can contact the DCA at askAnexpert@dca-global.org, and all this information will be available on the website. So thank you very much for tuning in, and I look forward to seeing you next time.